Hello?
Sorry, sir?
1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 1 2 3 1 2 3 1 2 3 1 2 3 Hello? Hello? Sharp. Sharp. Yo. Hey Desiree, I can hear you. Yang no andam fo. Mam tutu. Yebo amut ayanda. Sharp. In essence, Desiree, I under my colleague and Zimpwe Makanya, who were inside court now, just received a briefing from the Jacob Zuma Foundation on behalf of its patron, Jacob Zuma, that the former president is not feeling well as it downpours here in Pietermaritzburg. But Andam Hlongo was part of that briefing. We're going to ask her of the questions. And the Jacob Zuma Foundation says its patron, Jacob Zuma, the former president, is not feeling well. So in essence, this means the former president will not be making his way here to court in Pietermaritzburg.
Yes, indeed, Sam. Zanele Manye, a spokesperson for the Jacob Zuma Foundation, calling the media urgently to give us an update. That is that former President Jacob Zuma has been advised by his lawyers, by his doctors, not to be present in court today, as he said, as he is not well. According to Mr. Manye, at the moment, his lawyers are now meeting with the judge to determine how they're going to proceed. He did indicate that while they are in discussions in chambers with the judge, it might take some time for the proceedings to start. We had expected that the proceedings would have started at 10 a.m. this morning, but of course now with this latest development that the former president will not be in court, we'll have to wait to see what the judge says and whether or not the trial, which was set to start today, is going to be able to proceed.
So in essence, what we are seeing is that with the former president being ill and not being able to come to court, with this application of a private prosecution as well to prosecute Advocate Billy Downer, and his legal team's stance to want to bring an application to try and stop the criminal trial from proceeding today, will further compound what is perceived as a Stalingrad tactic by the former president to stop the prosecution of this 17 years long criminal trial.
Yeah, certainly, Sam, I suppose, but we will be speaking now to our legal expert, Mr. Mpumelelo Zigalala, just to, of course, take us through what is likely to happen now that the former president is not well and cannot be in court. Remember, Sam, that today, as we've said, was the start of the trial. The court had instructed former President Jacob Zuma to be present in court today, as well as a representative from Thales. We know that most of the time, I know we speak a lot about former President Jacob Zuma and less about his co-accused in the matter, the French arms company Thales, but their representative had also been instructed, and their representative comes from France, had also been instructed to be in court today. We'll have to wait and see what the judge says, but if former President Jacob Zuma is not in court today, it's unlikely, I suppose, that the proceedings will be able to get underway. But as I said, Sam, we are with our legal expert, Mr. Zigalala. Let's just chat to him on this latest development. Mr. Zigalala, thank you so much for your time this morning. We'll first start with this development now. Former President Jacob Zuma, his doctors have advised that he stay at home as he is not well. What is likely to happen now?
Probably an application is going to be made for the postponement of this particular matter, in which the former president legal team is going to make a presentation and say to the court, our client is not here, not due to his own doing, circumstances beyond his control, it's a matter of sickness, a matter of life and death, please grant us a postponement. Probably the judge will then say, provide some proof of saying that the president is really sick and can't be here. And they may come back and say, I don't have proof at the moment. If you give me time to come back either on the next occasion, I can provide that particular medical certificate, which is important. If all fails, whether it's by consent or maybe the judge and the NPA says that let's go to court, the Criminal Procedure Act is very prescriptive. It says under Section 342, capital A, there's particular reasons which are looked at by the court to determine whether this delay is reasonable or not. And certainly issues of health, especially when evidence is going to be led, are utmost important. The court does not want to lead evidence when the accused is not there. You must be able to see the start of the trial, hear what the witnesses are going to say, and certainly they're not going to do this particular matter in absentia. There may be provisions under the Criminal Procedure Act of doing that, but I don't think those conditions are alive here at this stage to say let's continue even if the former president is not here. So the chances are the matter is going to be postponed to another day.
Regarding the former president's illness, we know that it's not the first time that he has not been present in court. In fact, it was a time when an order by this court was granted that should he not appear in what was supposed to have been the next appearance, and a warrant of arrest was to be issued. There was a dispute over the medical certificate. The judge at the time, Judge Pillay, had questions around the medical certificate that had been submitted to the court by his legal team. So you are saying that today, in order for the judge to grant this postponement, they would then have to furnish them with a medical certificate that would be acceptable to the court.
Definitely, but also depending on when the illness took place. So if you are sick yesterday at night, you probably would have received the chance to go to the doctor this morning. By this particular time, you can't go to the doctor and get that particular medical certificate. So what they are going to do, they're going to say, grant us time. We are not disputing anything. We are not fighting with anyone. We just need adequate time so that we are able to file this medical certificate. We are well aware of what is going to happen. But what we can come here and say is that our client, which is the accused in this case, is not at court. He's not feeling well. On the next occasion, we're going to come with a full medical history and the instances which have caused this particular delay with the medical illness.
I want to go back, Mr. Zagalala, to speak about what we had expected to take place here today in court. The former President Jacob Zuma's legal team, the intention was for them to file an indefinite postponement, and that is due to the fact that, of course, he's approached the Supreme Court of a appeal to reconsider their decision, and that decision was after the court dismissed his review application for the SCA to review the Pietermaritzburg High Court's decision where it dismissed his application to have the state prosecutor in this matter recuse himself. It's a mouthful, I know, but this indefinite postponement, in your view, was he likely to get it? And I say this because the judge had made it clear. We were with you in the previous proceedings as well. The judge had made it clear that he wants this case to get underway and he did not want any more delays.
Of course, we're speculating because we haven't seen the papers, but it's very rare that a court will give out a decision similar to that one. Indefinite prosecution up until you finish traversing all the other courts is not going to suffice. Let's also remember what governs the way the procedures that must be followed in this case is the Criminal Procedure Act, and it is very prescriptive in terms of saying there are instances when you are not going to listen to any of the postponements application which you come with as the accused. If there's anything irregular or illegal that has taken place, the Criminal Procedure Act is going to take care of that. When you go through your appeal stages, that is what you are going to traverse and deal with those matters at that particular stage. For now, we still want the merits of this matter to be discussed, and we want the first witness to come into the witness box and discuss and give out the evidence. So I don't think that particular application would have succeeded. The judge would have said, I want to get this matter over and done with as soon as possible. In fact, I'm protecting your rights as the accused. It's per Section 35. It's your right that the matter must start and end within the shortest amount of time. There's been numerous delays in this matter. I don't want those delays anymore. Let's please get on with the matter.
The matter, though, that he wants to pursue his private prosecution of Advocate Billy Down. I was speaking to you earlier on that it's a recourse, I suppose, that a lot of people are not familiar with. Private prosecution. If you can just take us through exactly how does it work?
It's basically governed by the Criminal Procedure Act. I think from Section 7 to 18 it deals with private prosecution, but basically stating in instances where the NPA, which is the ordinary prosecutor of all us or represent us in court as South Africans in criminal matters, they will then say you're not interested in prosecuting this matter, and then you say to them, because you're not interested, please give me a certificate. I want the title to prosecute. Ironically, it's something which has been dealt with before in this court. I want the title to prosecute this matter on my own. I've provided the financial security just in case I lose the matter. I believe that I have merits. Give me that option because I want my instances or my matter to be traversed in an open court. So basically the president was going to do that. But it must also be remembered, it's not something which can be used to delay the starting of this particular matter. It is a private matter which is against the former president and Advocate Billy Down. It has nothing to do with this type of proceedings, and it had no bearing at all because this court is pronounced on it. The SCA, let's say part 1 of part 2 has been pronounced on it. We're still waiting for the Court to determine, but it cannot be used as any of the reasons in which are going to stop this particular proceedings from taking place.
And of course, the NPA has said in this matter that all of these are just tactics, Stalingrad tactics by the former president to delay, and they are going to vehemently oppose any application that he brings to this court.
I wouldn't agree with them to the fullest extent. Let's remember, these particular points or issues or legal frameworks that they're using is something which is available in our law. they wouldn't have been inserted or created if they were not meant to be used. So at the end of the day, if I have a client, in the case of the former president, I'm going to use all that I can to make sure that his rights are defended. So if I'm traversing all those particular avenues to make sure that he gets a fair trial, to make sure that he's able to get access to justice, those avenues are going to be used up until they've been exhausted, and then you can start with the main trial. So I don't think it's a delaying tactic. It's simply the former president saying, I have these at my disposal, I'm going to use them by all means. I'm still going to instruct my legal team to pursue them up until I get finality. I want to make sure that if I'm prosecuted, it is done so in line with the law, but most importantly, I must be able to see and hear justice being done.
Before I let you go, and I know we will be with you throughout the day, but another important point that has come up, that has been reported, is what is contained in papers that former President Jacob Zuma's lawyers have submitted to this court, where they, or some are saying that it's perceived or appears to be a threat to the court, where he is, we understand, reminding the court of what happened when former President Jacob Zuma was incarcerated, and the unrest that followed. What do you make of it? Do you think it's a dangerous line for his defense team to take?
It may be a dangerous one. Let's remember, why would you want to link your client to something which happened, which is very bad, and to something in which they've always came out and distanced themselves from it? So if you are going to say, do not let the legal frameworks, do not let the Constitution take precedent, do not allow the rule of law to reign, because there might be fear of certain unrest taking place. That's basically putting or placing the court in a corner. Let's call it legal blackmail. So you don't want to have to engage in those type of tactics, especially you don't want that type of content within your affidavit. If you want to argue and want to protect your client, still stick to the legal frameworks. Show the court which particular rights are going to be infringed by that decision, and show the court the level of success in which that is going to be attained if they traverse those particular legal frameworks and legal precedents. So I don't think that particular phrase should have been included. However, the legal team is at liberty to insert whatever that they want in an affidavit. Whether to sway the court, I don't think so. The court will always be independent. They'll always rule without any fear or favor, and make sure that the only thing they seek to protect is the rights of the accused, the Constitution as the states, and any other common law legislation which must apply to all the circumstances, especially in this particular case.
Mr. Zigalala, we always appreciate you helping us out and your analysis on these matters. I know you are going to be with us for the remainder of the day, but we do appreciate your time. Still a lot more to talk about, of course. As we said, that breaking news of former President Jacob Zuma will not be present here today at the start of his criminal trial here at the Pietermaritzburg High Court. Currently, his lawyers are in chambers with the judge and with the prosecution team to map out a way forward, Sam, in terms of what is going to happen. And while we've been focusing a lot on what has been happening on the inside of court in terms of what we can expect from the legal proceedings or the court proceedings expected to take place this morning, there's also a lot of attention and focus on the outside. Or in case today, it's in the court foyer because everybody's trying to run away from the rain. But just outside the court, once again, the road outside the court has been cordoned off by the police, a heavy police presence here outside the Pietermaritzburg High Court. Of course, police monitor and ensure that everybody who is here is safe and that there are no incidents that may take place outside. Sam, speaking about the people who are here to support the former president, the usual faces we see, a spokesperson of the MKMVA, Mr. Carl Niehaus, he's here. We've also seen Kosenje Shezi, responsible for the mobilizing of to mobilize support from the former president. We just saw Dudumieni as well walk past us early on. Usual faces?
Yes, indeed. The usual faces are here in court. We've not seen the likes of Supra Muhamapelo, who is the former provincial chair and former premier of the Northwest Province, who's a member of parliament. He's not yet here. The likes of Des van Rooyen, Malupse Kikaba, who's also been here to support the former president, is not yet here. I've seen those who work in the suspended Secretary General Ace Makashule's office, the likes of Chris. They are around. They've just left. In fact, now saying that the suspended Secretary General of the ANC is around town, and we did speak on the phone with him. It did did say he will be coming to court to support former President Jacob Zuma. He's been here for quite some time now in KwaZulu-Natal, particularly heading towards that eThekwini Regional Conference, which he says he never didn't know where the venue was, didn't speak to anyone, didn't have any meetings, but he is around town. And we've also seen Mthandeni Dlungwana, the former MEC of Education who hails from Mpendle and former regional chairperson of this region. He's just stepped out now to go do some of his own private business. He was inside court. So the usual suspects are here, and the usual supporters of former President Jacob Zuma, particularly after their gloating in victory with the victory of Zandile Kumete as the regional chair of eThekwini, whom, by the way, also supports former President Jacob Zuma. And she's not here in court right now. She was celebrating with her family after yesterday's victory. And our colleague, Piet Koen, did that excellent interview with her yesterday evening. So those who support former President Jacob Zuma are here. They are pledging their allegiance to him. And we are seeing those whom are in his corner in an upsurgence when it comes to electoral politics within the ANC once again in the province.
Yeah, certainly, Sam. I do believe, and you've always said that they use this court case as a platform, I suppose, for them to come together, the supporters of former President Jacob Zuma. This is the time where they are able to get the masses, to be able to speak to them on the current situation and the current politics within the ruling party. But yesterday we spoke to Pastor Vusi Duba, who also knows, also part of the committee that organizes the support for the former president. And he had said that why we're not seeing the masses here today would be, obviously with the start of the trial, they weren't too sure whether or not it was going to get ahead. But should the trial continue, he then said that they will be mobilizing the masses to come out here. But saying that they were not going to stop individuals who wanted to come and show their support for the former president. But today we are not likely to see the numbers outside and all the preparations with the stage set outside just opposite the court building. We're not going to see that today. They're going to play it by ear to see what happens today. And they said should the case then continue from tomorrow or continue into tomorrow, then they were then definitely going to have the masses come out here. But of course now with this development, Sam, with the former president being ill, and we'll just have to wait and see what the court says, whether or not the matter is going to proceed. It's, as we said this morning, it's all in the former President Jacob Zuma's court.
Indeed, it's all in the former president's court right now, and he is seemingly ill and he will not be here in court today. The political theatre will not be taking place today. There will be some of it in the foyer of the court, but when it comes to the market square here in Pietermaritzburg, there will be no such political theatre. As it rains and pours down like cats and dogs, there will be no political theatre. Those who support the former president, some of them will be making their way. The leaders will be coming through to support the former president in absentia, as he's currently ill and will not be in court, as the political theatrics and the political tectonic plates shift in the province back in favor of former President Jacob Zuma, with Mama Zandile Kumete being elected as the regional chair of eThekwini and Tumbo Ntuli being elected as the deputy chairperson of the province, who's effectively now the acting chairperson of the province, with Mam Zandile Kumete having stepped aside. Mam Zandile saying she will be there on an advisory role, advising those who are in and who have been elected. But the political theatre currently is in court as the legal and the politics join together, as you've seen those papers by former President Jacob Zuma. When it comes to the letters and the affidavits he submitted to Judge Piet Koen linking the July unrest to former President Jacob Zuma, should this criminal trial proceed with the events that we saw last year with the arrest of the former president. Back to you in studio, Desiree. Well, and I'm just going to quickly bring in Some of the points that Mzwanele Manye raised in that impromptu briefing, what are some of the points that he raised besides the former president being ill and the lawyers of the former president and the state now being locked behind closed chambers with the judge? What are some of the other points that did Mzwanele Manye raise?
Sam, he stuck just to that, to say that he is going to be updating the members of the media and the country shortly once they get a report back from the lawyers regarding the former president's ill health and how the court is going to proceed. They are going to be giving us, once the lawyers have met with the judge and have met with the prosecution team, they are then going to be giving us an update in terms of the way forward. And what we can expect today.
Well, and thank you very much. I've just seen visuals now of Judge Piet Koen entering court over to the court for the judge's proceedings to start.
Thank you, my lord. Mr. Jackson, I appear on behalf of the second accused, and maybe whilst on my feet, my lord, you would not necessarily note, but there is a different representative on behalf of Thales in the dock. We have a resolution. The reason is that the previous representative is not available and we did not want to cause any delay in this matter. I beg leave to hand up the resolution. I have discussed it with Mr. Downer and also with the other representatives. You would see that it makes provision also for a second representative, but just that's in case there's a problem when he's sick or whatever the situation is, can't be here for a day. The new representative, my lord, that you will see from the resolution is Mr. Olivier, and the pronunciation of the surname is Kuzerka. Kuzerka. It's Mr. Olivier Kuzerka.
Kuzerka, okay.
Kuzerka. And we asked the court to consider to then accept him as the new representative.
Yes. Shall we make this a further exhibit?
I think
we're down to exhibit E.
Exhibit F. Your lordship's registrar told me exhibit F.
So this will be F.
F, yes, my lord.
Thank you.
Thank you, Madam.
Yes, the resolution passed by the Board of Directors of the second accused will be exhibit F. And I've taken note of the fact then that Mr. Kuzerka is present here today.
He is indeed.
Thank you. Thank you, Mr. Kuzerka. Thank you, Mr. Roo.
My lord, could I just say that is in terms of section 3322B of the Criminal Procedure Act, and that if your lordship has regard to that, it's strictly speaking at the application of the prosecutor. Now, I absolutely have no problem with it at all, and so I formally make that application.
Thank you for pointing that out. Thank you. He is then so appointed as the representative. Yes. In the order of business, I think, Mr. Mpofu, you next to speak, is it?
That would be correct, my lord.
Yes.
Yes. My lord, if I may just start with a few housekeeping issues. Firstly, as we indicated to your lordship in chambers, your lordship will notice that the first accused is not in court. There was a medical emergency which took place in the past few hours, and we have been liaising with the doctors. The situation is being attended to. I've now, since we spoke to you, my lord, been assured that we might get some kind of document later in the day. But be that as it may, the proposal that we had discussed in chambers was the possibility of being able to proceed in the absence of the first accused. And obviously, as I indicated to your lordship, I had to get instructions in that regard. I'm happy to announce, my lord, that I have since received those instructions. And so we will be able, we'll monitor the medical situation, but, and I've personally spoken to the Surgeon General.
Surgeon.
Yes, so I kept on calling him the district surgeon earlier, but he's the Surgeon General. And and he has given me that assurance. Now, the basis, of course, of the agreement was that is similar to the previous one that we had, my lord. You'll remember in September, where the accused had, although he was entitled to be present, for the sake of progress, agreed that we could argue the Section 1061H matter on the 21st and 22nd of September.
Yes.
Mr. Downer and I have identified what we think is the correct section, which incidentally also deals with postponements, but also deals with absence in general, as Section 159(2)(a), Roman 1, my lord.
Yes.
Yes.
Yes, as I understand it, he's instructed you that the application for an adjournment can proceed in his absence.
That's correct.
He waives his right to be present during those proceedings.
Yes.
And no consequences will follow from him not being in attendance.
Yes.
Because
in the same way.
Because in any event, everything is on affidavit.
It's an affidavit, my lord. As I say, we're exactly in the same position we were in September last year, where practically it's an application, although we know it's in the criminal court. So, yes. So
Yeah.
that is it's that same arrangement, my lord. Maybe Mr. Dana can confirm.
Yes.
that
You
is-
confirm that, Mr. Dana?
I have no objection, my lord.
Yes. Yes, it's noted then that Mr. Zuma is absent. He's not in personal attendance, and that he has agreed to the matter proceeding. When I say the matter, the application for postponement or an adjournment proceeding in his absence.
That's correct. Right. My lord, oh yes, another housekeeping matter is that actually how we got to know all this is that last night we were supposed to be consulting with Mr. Zuma, and he couldn't make it. And one of the reasons for that consultation was, of course, he would have signed the supplementary affidavit that would have reached your lordship on Saturday. I've mentioned to Mr. Downer that we have therefore not been able to have that signed. He has no objection in it being referred to. If need be, the formality of filing a formal one would follow.
Yes, Mr. Downer, you confirm that as well?
I confirm that, my lord.
Thank you. From our side, I don't have a problem with that. The unsigned copy that I had, or that I was given, referred to an annexure being the cover sheet
The face,
of filing
yes.
the reconsideration application in Bloemfontein.
Yes,
I obviously do not have that, and if that can be handed up and I can see the date on it,
Yes.
then I'm satisfied that
All right, my
that part
lord.
of the factual matrix is also
Is
established.
done. Yes. My
I was
lord,
told it's the 8th.
it is, my lord. You can take it from me for now. We will generate that, but it's definitely stamped the 8th. It was delivered. It was filed here on the 7th and with the other side, but delivered in Bloemfontein on the 8th. And we will ensure that your lordship gets that copy.
Yes. Thank you.
Thank you, my lord. My lord, then, my lord, coming to the issue at hand, my lord, this is a matter that really should not detain us for long. And I'll just map out what I think are the parameters, my lord. I've got about 5 different parameters which I will use. Hopefully not use all of them. The first one relates to the matter that is pending before the President of the Supreme Court of Appeal under Section 17(2)(f) of the Superior Courts Act. That is referred to in the papers. Then, and that is the important issue that we want to dwell a little bit on.
Yeah, that's the reconsideration application.
That's the
If
reconsideration.
we can refer to it as that.
Yes.
Now, it seems to me, Mr. Mpofu, that the factual matrix here is pretty much common cause. I gave a judgment dismissing the special plea. There was an application for leave to appeal with certain adjunct procedures attached to it, which was dismissed in February 16th, if I remember correctly. And thereafter followed a petition, an application to the Supreme Court of Appeal to obtain the required leave where necessary in respect of of my main judgment, and that was considered by 2 judges of the Supreme Court of Appeal and was refused, dismissed, I think was the term used, on the 18th, was it?
30th.
Sorry, the 30th.
28th, but it's stamped the 30th.
Yes,
but
yes.
Nothing turns on.
But last week,
Yes.
and then following on from that, an application for reconsideration, if I may term it that, in terms of Section 17(2)(f) of the Superior Courts Act, or pursuant to the provisions of the Superior Courts Act 10 of 2013, was then, as you indicated earlier, issued out of the Registrar of the Supreme Court of Appeal on the 8th, after having been issued or served here
Yes, correct.
on the 7th of April 2022. And the issue really becomes one, without wanting to limit your submissions,
Yes.
as to whether this court, I think, has a discretion but to allow the appeal process to run its course.
That's correct.
And then I say the appeal process, i.e., that the President of the Supreme Court of Appeal must consider and reach a decision on this application, the reconsideration application. And that is the case that was made out, or the case initially made out in the application for an adjournment, was based on the petition still being pending.
Itself, yes.
That has now come and gone. It's been overtaken by events. But from the correspondence, which I was copied as well from Mr. Tusini, Mr. Zuma's attorney, and the response of the state from Mr. Downer, it has been broadened to the extent that it now deals with the reconsideration application, which is common cause. It is there, it's in existence, and it's really the consequence that needs to, or that will flow from that.
That's correct. Yes.
And that will entail more specifically a consideration, amongst others, of Section 17 and it seems to me 18 of the Superior Courts Act. The initial application referred to Section 18 fairly obliquely,
Yes.
sort of just at the end. It wasn't the main thrust
True.
of the initial application for an adjournment, but it's certainly grown in stature
Yes.
in the heads of argument. And I think if we can focus our minds perhaps on that,
Thank you, my lord.
then, but as I say, without limiting you, but that seems to me to be the issue from having read the papers and having read the heads of argument.
Yes.
And you don't need to repeat. If you want to refer to any specific allegations in the affidavits, well then obviously you're at liberty to do so, but I've read them.
Yes.
If you want to emphasize anything, please do so, but otherwise let's not repeat them.
Yes.
Thank you.
No, my lord, my lord, you have summarized the what I call the first issue. Maybe what I should then do, my lord, is just to outline the issues that I was going to outline, but return to this issue that your lordship has flagged really as the main issue. Yes. I'm indebted to your lordship. Yes. Well, then the issue number 1 is the reconsideration application, as I said. Issue number 2, which has also been raised in the papers, is the issue of the private prosecution that is contemplated. And issue number 3, which is of lesser importance in the context of today, is the, well, let's call it the Section 179 letter, which was written to Advocate Batoi, in respect of which we received a response also on Friday the 8th. That your lordship will find as an annexure to the supplementary affidavit of the state that was served on Saturday, that was delivered on Saturday. So I call those if we get there, I will call them the 3 court proceedings. First one here in front of your lordship, the second one in front of the SCA, and the third one possibly in front of whoever will hear the private prosecution. So those are the three issues, my lord. The two, what I call the two defenses, which is the other issue, that have been raised are simply, if you cut all the verbiage, the one defense that is raised is around prospects of success, and the second one is the so-called Stalingrad. So that's just the roadmap, but I'll take your lordship's direction and then return to what is obviously the crux of the matter. Now, my lord, your lordship has already said in your summary that Section 168 is a very simple section of the Criminal Procedure Act. Its elements are really that a court may, emphasize the word may, which is where the discretion that your lordship spoke about comes from. If it is necessary, if it deems it necessary and expedient, adjourn a matter to a date to be determined. It's common cause that all the other ingredients, these criminal proceedings and so on, are met. The only issue really before your lordship is whether your lordship is how your lordship would, in this particular case, exercise the discretion. It's also tried, my lord, that that discretion must be exercised judiciously and not capriciously. And it's common cause that it must be steeped on the particular circumstances of a particular case. There'll be no controversy there. The issue then, my lord, it has been set out in many cases, including State versus Atchison, the broad principles which should guide the court in these matters. One, on how that discretion should be exercised. Number one is the interest of society in making sure that guilty persons are punished. And we have we have pointed out that obviously deals mainly with situations where a person has already been convicted, because as you know, your lordship, such postponements are usually between, for example, conviction and an appeal, which is not the case here. The second...
Mr. Boffa, may I interrupt you there? Sorry.
Yes,
and I hope I'm not disturbing your train of thought.
No problem.
I understand the principles relating to the exercise of a discretion. For example, where an application for an adjournment is made in terms of 168 because a particular witness is not available or a particular set of circumstances have developed or whatever. Do I have such a discretion where the reason for the adjournment is to exercise rights that are ordained by statute in an appeal process?
Well, my lord,
because if I have to exercise a discretion on that point, I have to make an assessment of the strength of the case. When I say the case, what will serve before the President of the Supreme Court of Appeal in the reconsideration application. And the issue to be considered there, or reconsidered, is whether leave to appeal should be granted in respect of my main judgment, where, well,
on the
refusal, yes, the 106.1H, when it's reduced to its ultimate conclusion, on which I've already expressed a view.
Yes.
So, as much as it's pursued in terms of 168, what is my discretion?
Yes.
To say, just tell me about my discretion,
Yes, my lord.
to say that I'm going to deny someone a right which he or she might, well in this case he would have, as provided for by statute.
Yes. Yes, my lord, the short answer is your lordship does not have a discretion. If your lordship does have a discretion, it's an extremely narrow one, and I'll explain it just now, my lord. The lordship is quite correct that the the issue, the nub of the issue, which is the third element that I was going to go to, is the impact of a refusal on the applicant's constitutional rights. And that comes directly to what your Lordship is talking about. Your Lordship will know that the general rule is expressed as follows. A court should be slow to refuse a postponement application where the constitutional rights are implicated unless the sole purpose of that application is to create undue delay.
I understand that, but that
Yes.
presupposes I have a discretion.
Yes.
If I don't have a discretion, then what rights are implicated becomes a subsidiary inquiry.
Well, I wouldn't put it that far, my lord. I would say it's because of the rights that your lordship might not have a discretion, if you know what I mean. It is exactly because, as your lordship correctly pointed out, any person is, by dint of the Constitution, entitled to exercise their appeal rights. And your lordship has alluded to that. And that comes from either Section 35(0) of the Constitution. But because we've had a debate about that, we can put that aside. And we can even leave it at the level of Section 34 of the Constitution, my lord. Because after all, we're now in the land of Section 17 of the Superior Courts Act. So a person, in any event, has a right to exercise their right of access to court. And therefore, that is what, in a way, limits, quote unquote, the discretion of your lordship, or almost takes it away.
You see, it's also not a case anymore. I don't want to regurgitate what I said in my main judgment, but I found that there was no right of appeal prior to conviction, for example.
Yes.
And I dealt with the issue of whether it's an appeal
Whether it's
in terms of the
appealable.
provisions of the CPA, the Criminal Procedure Act, or whether by virtue of the definition of appeal in the Superior Courts Act, it falls under Chapter 5 of the Superior Courts Act. But that debate doesn't arise anymore.
No.
Because there's now an express provision, being Section 17(2)(f),
Absolutely.
that deals with reconsideration. 17(2) earlier deals with petitions, and then 17(2)(f), where it's refused, and then the proviso. So we're now in the realm
Absolutely.
with the Section 17(2)(f) application, it seems to me, subject to what Mr. Dana might say later, we are in the realm, clearly, of the provisions of the Superior Courts Act. And then if the provisions of if it's a procedure, it's part of the appeal process, in terms of the Superior Courts Act, then it's an application also for the purposes of Section 18,
Correct.
which is also part of Chapter 5 of the Superior Courts Act. And if that is so, then 18(1) says the decision, being in this case now, the decision of the two judges refusing the petition is suspended. Now, on what basis do I interfere with that?
No, you can't, my lord.
18(2), sorry, I'm interrupting you.
Observer.
Mr. Downer's, the state submission said, well, 18(2) is the one that applies, that it's an interlocutory order.
Yes.
But, and we'll hear what he says, but you might want to comment on that.
Yes, I will.
The decision is the refusal by the two judges of the SCA. I'm not sure, well, I don't quite know why it is said that that is an interlocutory order.
No, it's not.
It's a
my lord.
final order, is it?
It's final. The Constitutional Court has said many times, including the case of Lishing, my lord, which we cited, that,
Yeah.
that two things. That one, that decision is final. Two, which your lordship has already paraphrased now, in any event, the reconsideration application is part of the appeal process. That's clearly set out in the Lishing case. But my lord, let me, your lordship has...
And
has,
three, sorry to interrupt you again, three,
Yes, ma'am.
Lishing, I think Lishing 2 said 17(2)(f) clearly applies also to criminal matters.
Absolutely. Yes, even Lishing 1 said it, but Lishing 2 definitely said that. And Klute, the case of Klute, which was subsequent, also said the same thing. But let me zoom into your lordship's last point. And your lordship, firstly, as we have set out in our heads, the case really rests on the relationship between what is happening in the SCA and Section 17. The Lordship is quite correct. If anything, the refusal or dismissal of that petition by the SCA has removed any confusion as to whether we are now in the land of the Criminal Procedure Act or in the land of the Superior Courts Act. It's very clear that we are now in the land of the Superior Courts Act, Section 17. And there's a reason, my lord, why Section 18 follows Section 17 in the Superior Courts Act. It is because the two sections are symbiotically intertwined. Because the opening words of Section 17, of Section 18(1)(a), as your lordship will know, say that whenever there is an appeal or an application for leave to appeal or an appeal. In other words, is the application for leave to appeal that has been dealt with. Remember, the heading of Section 17 says leave to appeal. So it is that leave to appeal. So there can be no doubt whatsoever that we're at least now dealing with a Section 17 application for leave to appeal. And if that is so, then Section 18 kicks in automatically. And Section 18 says that that decision is automatically suspended.
The operation and execution.
The operation and execution of that decision is suspended. Now, that being the case, my lord, that would then mean, and your lordship is quite correct, the state incorrectly identified it as an 18.2 issue. But even that can be, let's even say it was an 18.2 issue. That would be, that argument would be disposed of on the following basis. That it is even hit by the exception in 18.2, which is that it is final in effect. Remember, 18.2 says whenever there's an interlocutory application which is not final in effect. So that means whether it's 18.1 or 18.2 might be of interest to academics. But the point of the matter is that this is a final judgment. Alternatively, it is one that is final in effect. So whether it's 18.1 or 18.2 really then doesn't make any difference. Now, if that is so, my lord, if we are indeed in the area of Section 17, then your lordship's question becomes even more pertinent, because your lordship then clearly does not have a discretion there. That discretion would only arise if there was a Section 18.3 application brought before your lordship.
Oh, well, there isn't.
There isn't. So your lordship's hands are tied.
Well, then is it cadet quaestio?
Cadet quaestio, my lord. That's it.
No issue of discretion.
No. It's by operation of law.
It's suspended by operation of law.
By operation of law.
And with deference to the procedures and the jurisdiction of the SCA, represented, well, where the application is going to be submitted to Her Ladyship, the President of that court.
Has been, yes.
Has been submitted, or has to be considered, and a decision reached. We've got to await that, is it?
That's correct, my lord. So, yes, my lord, in summary, my lord, before I sit down, one can look at it from two angles. If you looked at it from a Section 168 point of view, then your lordship, because of the Section 34 rights involved and the right of appeal, would still have no discretion, or a very little one, a very narrow discretion. But if you look at it pragmatically and realistically as an appeal that is, or a process that is under Section 17, then by operation of law, the underlying decision is suspended. And the lordship, with due deference and respect to a higher court, would have to allow that process to proceed. And if there was any discretion, then the only way out for the state would have been a demonstration, a clear demonstration that this is not a legitimate exercise of the rights that are in the Constitution or in the section, but merely a delaying tactic solely. And there's nothing except speculation and gossip and all sorts of things like that, that has been put in front of your Lordship, even in the unlikely event that your Lordship had such a discretion, which in our argument your Lordship doesn't. The last point, my Lord, just so that my learned friend can address this, is the second, what we call the primary issue is the adjournment itself. The secondary issue is obviously until when. And that issue we have addressed, my Lord, by in our primary prayer, we have asked for a postponement sine die. The Lordship is aware of the cases on that issue. There's a case of Cottenberg that my learned friend have relied on. To paraphrase, my Lord, what the courts have said is there was a belief at some stage that you could not adjourn a criminal matter sine die. That belief has now since been dispensed with by the courts, but obviously with the usual caveats. And one of the caveats is that the court may, under particular circumstances, grant a postponement sine die, but alternatively, the court may give what is usually known as a long postponement, just so that the parties would come back and report to the court. But my experience, my Lord, in this case is that the parties have really been cooperating very well with each other. I'm sure that if any circumstance arises, then we can, get the wheels of justice reignited, so to speak. And therefore, we remain with our primary prayer, my Lord, of an application sine die, subject to whatever caveats your Lordship might or conditions might impose on us to communicate as and when something happens. But it's, as my learned friends have correctly pointed out in their affidavit, it's impossible to know how long these processes might take.
Mr. Mpofu, if I'm not with you on that point, and because this matter enjoys a lot of publicity.
Correct, madam.
It's important.
That's correct.
From the state's point of view. It's important from Mr. Zuma's point of view.
Yes, and the public.
Prima facie, it seems to me there should be judicial oversight of the future of this matter. And I am prima facie not disposed to adjourning it sine die. But to give it time, that's now if I should decide that the matter cannot proceed today.
That's correct.
To some future date, to await the outcome of what's transpiring in the meantime. I note what has been said about any further proceedings, but at the moment they don't exist.
No, they don't.
This application has to be decided in the context only of the reconsideration application. That is what's before the court, and that is the next process. Because what might happen thereafter, it might not be pursued any further at all.
It might not happen.
Yes. In which case, then everybody has to be brought back, and I don't know when it might be, but counsel might not be available anymore, because at the moment we have this term and the next term. So I'd like to hear you just on what, if I was disposed to adjourning the matter, what the date should be, if it's a specific date, taking into account your experience and my experience and everybody's experience of these matters before the SCA. Petitions, we all know, are dealt with expeditiously. They within normally a couple of days, like in this matter. I don't know how long the president of the SCA might take to consider the reconsideration application, and obviously we don't know what she might do.
To return it to the two judges on.
Well, there are a number of possibilities. If she should entertain the application, that might arise. So I'm prima facie, as I say, if an adjournment was to be granted, that it will be for a month or 6 weeks or whatever the case may be, but to a holding date, on which day either the decision of the Supreme Court of Appeals president is still awaited, or it might have been given and nothing further is developed, in which case the trial can proceed.
Yes,
I want to make it a holding date because I don't know what the position is regarding Mr. Kuserka, but certainly if, like the previous representative, he's traveling from France, then I don't want to make it a wasted exercise.
Yes.
So I think one can model some sort of an order that there's a holding date, and if by that holding date it appears that the trial is ready to proceed, that it'll continue, say, a week later, start a week later. That'll address the concerns of the state with getting witnesses here at costs, and it'll also address the concern or the potential prejudice to the second respondent, or part of their prejudice, beg your pardon, the second accused, that a trip is not made to this country unnecessarily. Do you have any comment on those thoughts?
My Lord, I'm with your Lordship. Obviously, with so many balls in the air, that cries out for judicial supervision and an obligation on our part, at least, to report to the court. Therefore, my Lord, subject to what my learned friend has to say, I would, I'm just trying to visualize now my diary. Towards the end of May might be the comfortable time to do the holding date, and then we can take matters from there. Let me just check with my... Yes, my Lord. I know I have a problem in the first week of June, so it would have to be just before that.
It's just a holding date. It's
the holding date.
Yeah, it's a holding date, on which date it will either be, well, in a week's time we start the trial,
Yes.
and everybody get their witnesses and their representative here,
No.
or
report back.
it hasn't. The President of the Supreme Court of Appeal is still considering her position, or she might have directed some process to be followed which might not have reached its ultimate conclusion. One doesn't know. But a decision can be taken on that day, and either it's adjourned then to a further holding date, or, as I say, it proceeds.
Agreed, my Lord. I have no problem.
Oh, no, I've still got...
Settle it later.
Yeah. Okay.
Yes.
No, broadly, my Lord, of course, we can't give
Yeah.
specifics because we have to look at the others. But broadly, we are in agreement with that arrangement as a broad arrangement,
Yes.
my Lord. Holding date, report back, and then whatever happens, happens. And then
Yes.
we will explain to the court what would have happened with the SCA process or any further process if there's any further process.
Well, at the moment, I'm going to... I deal with this matter on the basis of what's before me.
That I appreciate that, my Lord.
Paragraph 1 of your application for an adjournment said the trial and all other related proceedings. It'll be the trial,
Of course.
if the order is granted, is adjourned.
Yes.
Can't have an open-ended all other proceedings, because what does that mean? And it'll be that the trial be adjourned pending the outcome of the reconsideration application.
Yes, my Lord. Well,
If you're going to pursue something thereafter, well, then it might require a short affidavit by a return date, or when I say return date, a holding date, to explain that such a procedure has been invoked. But further procedures might not necessarily follow.
they might not.
It might depend on how the SCA treats it. The SCA, well, I think there's no better example than, was it the application for a permanent stay?
Moyo.
No, but in this
Oh,
matter,
yes,
the application for a
in this
permanent
case,
stay.
yes. The permanent
Petition was refused, application to the CC, but they're not persisted with. So that situation might arise. Let's not anticipate things. I'm going to deal with what's on the papers before me.
Agreed, my Lord. Your Lordship cannot speculate so far into the future. That's the whole purpose of
Yes.
reporting back.
Mr. Mpofu, the only other point is, by going to the end of May, if that is the date, obviously the time for the trial, should it resume shortly thereafter, is being condensed, because at the moment what is being reserved are the second and third terms. And I would then suggest, if that was to be the order that would follow, that the fourth term of this court's calendar year also be set aside for the purposes of the trial.
Okay, my lord, can we try, maybe let's not resolve that now in court, because that's going to involve a whole lot of issues and
Yes, what I'm trying to
and
avoid.
diaries, yeah.
What I'm trying to avoid last year, when the special plea initially arose, I was prepared to deal with it during the recess. But
I
then
remember.
all kinds of counsel weren't available, and if you start looking at the availability of counsel at the end of May as opposed to now, then it's becoming more problematic because it's closer in
that, my
time.
lord. No, I can commit
And
to your lordship.
As I say, if an adjournment is to follow, I'm fairly resolute on this point that I'm going to direct that it run to further in the year.
Well, your lordship, of course, has the power to direct whatever your lordship wants to direct. At least, but it can be directed with our agreement until I've spoken to.
Well, that's what I'm hoping to invite.
As court pleases.
Yes.
My lord, on that basis, then those are our submissions, my lord, and we agree broadly with the practical proposals suggested by your lordship, if in the end the application is granted.
Yes.
As court pleases.
Thank you. I suppose in the order of things, before I hear the state, Mr. Baru, you want to add anything?
Yeah, nothing to add.
Okay, thank you. Mr. Dana, I think you've heard the exchange. I've read your heads of argument and obviously the affidavits, and there are some very telling points that are made. But my primary difficulty was this question of a discretion, and whether I have a discretion where I'd found, and I hope for good reason, that the judgment on the special plea wasn't as yet appealable. We're not in that realm anymore. We're now on a Section 17(2)(f) reconsideration application, which is expressly recognized in terms of the Superior Courts Act. And it seems to me then that Section 18(1) must play a role. I see you said it was 18(2). That's the more correct one. But it seems to me that the outcome of this application is largely dependent on those considerations. And having said that, I'll leave it to you to make your submissions.
Thank you, my lord. Yeah,
Yes.
that certainly gets to the nub of the issue,
Yes.
and is a central difficulty which faces the state and which faces your lordship. And might I just say, my lord, that first of all, our submission will be that the discretion in terms of Section 168 remains, despite whatever may be happening up the line in the Supreme Court of Appeal and the Constitutional Court in the Section 17 and Section 18 realms. So the submission is yes, the discretion remains. The question simply is, how is the court to exercise that discretion? And that then takes us, my lord, to the particular circumstances of the current case. And might I just also say up front that my learned friend has conceded a concession if mala fides were to exist. In other words, were this court to be of the opinion, and this is the state submission, that indeed this application, which currently is before this court, is mala fides in the sense that it is part of the Stalingrad defense and is meritless, and is but one of those defenses which is raised continually without any prospects of success, knowing by any proper reading of the law, and is nevertheless proceeded with. So it's done in bad faith. It's done to delay in that sense, and we make this submission very seriously at this stage.
Well, it'll then be on the basis, correct me if I'm wrong, that 18(1) says it's suspended, but I must then say, well, you can't, accused number one, avail yourself of the benefits of Section 18(1) because what you're doing is an abuse of process.
Yes, my lord, and that's this court's decision, my lord. It doesn't. It's whether 18 operates and suspends the SCA's order is just in the background. But that doesn't mean that there is no discretion in terms of Section 168. And if I could just then develop the argument, my lord,
Right.
and here I'm going to just referred in some respects to our heads of argument.
Yes, let me just get them.
And first of all, my Lord, just up front, could I refer your Lordship to what the SCA said, what Navsa, Justice Navsa ADP said in the SCA in Zuma versus the Democratic Alliance case, the 2018 1 SA 200 SCA, which is quoted in our heads.
That's the spy tapes.
Yes, indeed, my Lord.
Which paragraph of your heads have you reached now, Mr.
This is just by way of introduction.
Sorry.
Yeah.
No, I thought you were going to refer me to a
Yeah.
specific.
But in the judgment there, he quoted T.S. Eliot, who said that
Oh, yes. I
he
remember
spoke
that.
with the recurrent end of the unending. And so our principal submission is that should a postponement be granted, today's date of the 11th of April 2022 will be yet another recurrent end of the unending, 4 years later, with any number more of recurrent ends in sight, without end. And this despite today's date being agreed between all the parties as a trial date, without qualification, and which the court twice ordered as the date on which the trial must finally commence.
Yeah. Admittedly, that was before a petition was lodged.
Yes, but it was after this court had given the judgment.
It was part of the judgment on the leave to appeal.
Yes,
Yeah.
on the 16th of February this year. So one would have expected that if the trial date were to be agreed upon, there would have been an agreement or an attempt at an agreement or an indication to the court, oh, but that's only a trial date if we do not yet have a result of the appeal from the SCA or from a 17.2F application to the president of the SCA. There was no such qualification. It was a trial date, and it was agreed by all, and preparations are made on that basis. But then that's not all, because today's agreed trial date came after nearly 2 decades of delays. And who has responsibility for those delays is a subject matter of many legal proceedings and many court pronouncements and argument, but nevertheless there have been those delays for 2 decades. And my Lord, to return to the heads, I refer to our heads at pages 31 to 39, that's paragraphs 79 to 90, and there we deal with the heading, a postponement being in the interest of justice or not. I think my learned friend and I are ad idem that section 168 and the discretion which we say still persists is exercised, which if in the end of the day the court regards it broadly in the interest of justice to do so, if it's expedient and would serve the parties and the court and society. So we say then that the court has a discretion in terms of section 168, whether to grant the application in the interest of justice, determine that the application should be dismissed. We go on in our heads to say that the application for postponement was first to await the SCA's order, and then once this order was dismissed on the 28th of March, the application changed, being to await the further orders of the President of the SCA and the Constitutional Court. Your Lordship has confined it only to the SCA proceedings. We would obviously agree with that because there's nothing else on paper and the Constitutional. But it is an issue because whether or not the Constitutional Court application is proceeded with, it is a factor which the court can consider that potentially lengthens the postponement sought and lengthens the number of proceedings which have to be completed before this trial at last can proceed.
But
So
it might never happen either.
Indeed, my Lord. But nevertheless, and once again, if one looks at what happens with the Constitutional Court application in this case, which your Lordship was referring to, which was ultimately withdrawn, in the permanent stay application, it was made, and papers were filed, periods had to go past, once more delays. Ultimately, it was withdrawn. And the question was, well, why was it made in the first place if it was to be withdrawn later? And our submission is that it is because it was always without merit and should never be made in the first place. And that meritless application procedure applies to the various applications in this case. And as I've said, my Lord, as our heads say, this court found that the first application bore no reasonable prospects, and the other petitions were dismissed in the SCA. So the SCA did if one doesn't take account of the application of Section 17 and the effect of Section 18, perhaps, the SCA has ruled that and agreed with your lordship and enforced your lordship's findings that there are no reasonable prospects of success.
And that was a final decision.
And that was a final decision. And so we say that the lack of reasonable prospects is based inter alia on this court's finding that neither the CPA nor the Superior Courts Act provide for an appeal in a criminal case at this stage of the trial before an accused is convicted. The enactment of the Superior Courts Act that effectively disallowed criminal appeals to the SCA before conviction was designed to prevent piecemeal appeals and delays in criminal matters. So our heads go on to say that should the application for postponement be granted here in this court in terms of Section 168, pending the result of the applications to the President and any further leave to the Concourt, which we've discussed, the effect in delaying the trial will be to achieve what this court, the SCA, the legislature, and the interests of justice seek to avoid. And that is perhaps our main point, my lord. It makes this case special, given its background in the delays and the effect of the countless applications, all of which have been refused.
So you are quoting from paragraph?
My lord, I'll have to get the.
Okay.
I'm summarising it now.
Sorry. Okay.
Yeah, but so, if in a case such as the present, appeals during the trial are not allowed, policy reasons say that that's good. Your lordship has found that that is good. The SCA has confirmed that that is so. If this application for postponement is granted pending further appeal procedures, that means that the effect of your lordship's judgment, giving effect to the policy of the legislature and good order in court trials, that would be frustrated. And that is a central frustration in this case, because we just can't seem to get anywhere, because even though the law doesn't allow what is now happening in this court, nevertheless, this court is being asked to postpone the matter.
Well, maybe if the law doesn't allow it, you say, but what about Section 17(2)(f? Clearly deals with and allows a situation of a reconsideration.
Absolutely, my lord. But that happens in another court. And
happens in another court,
yeah.
But mustn't that procedure be allowed to run its course?
Well, that is essentially
in the absence of a clearly abuse of a process, mala fides, etc., which I hear, and I'm very alive to the fact that this matter runs for many years, and there are many decided cases, and there are frustrations that have been experienced. But can one exercise a discretion to say, well, a statutory ordained appeal process should be forfeited unless it's the strongest possible evidence to suggest that it's being abused?
Yeah. Well, number one, and again, my lord, we say that it is being abused, and we develop that argument in our heads. And second of all, we say it's not a denial of the right happening in the other courts, because what this court does in this case by refusing the postponement will have no effect on the Section 17(2)(f) application for which this postponement is sought. It won't affect whether the SCA makes a decision, and it won't affect whether any further appeals are lodged. The SCA will continue doing and considering the papers before the SCA.
But what about the provision in the legislation that it suspends the operation and execution?
Well, it doesn't suspend the operation and execution of this court's.
No. When it refers to, sorry to interrupt you, when it refers to suspending the operation and execution, it refers to the decision being appealed, which is the decision of the two judges in the SCA.
Yes.
Sorry, not appealed, being considered.
Yes, absolutely. No, quite right, my lord.
So it's not this court's decision.
Not this court's decision, no. So it has that Section 17(18) procedure has no effect on this court's, it has no legal effect. It doesn't suspend this court's order. And it doesn't suspend this court then continuing in carrying out and executing this court's own order. And that was the first one. The second point is that it doesn't affect the fair trial rights of the accused, because the appeal is continuing in the SCA to the President of the SCA in terms of Section 17(2)(f) and later even the Constitutional Court. But this court's proceedings here today And this court's decision and the trial proceeding, if this court were so to determine, has no effect on the accused exercising his rights in terms of the higher court's hierarchy, when, rather anonymously, the provisions of the Superior Courts Act, which don't apply in this court, do apply in other courts.
But if it suspends the operation of the order on petition, in other words, the order of the two judges and the SCA, then that means there's no decision on the petition,
Well,
because that decision has been suspended.
indeed.
So then one is
yeah.
dealing with a situation where there's a pending petition.
Yes.
And does that not suspend?
Well, we would know. We would also say that that this court is within the realms of the Criminal Procedure Act, and this court's order is not suspended, because this court's order remains. So it's a very particular circumstance of the current case, which is based then at the next part of our heads, which is where we develop the argument relating to the Stalingrad defence, and that's, my lord, at pages 31 to 47, in paragraphs 79 to 120. Your lordship will be very alive to the issues there. Your lordship has been through it all before. It's simply a summary of all the cases where there have been comments which, generally speaking, are adverse to the Stalingrad strategy in general, and particularly to the accused Stalingrad strategy in the current case. And that's what makes this case peculiar, because, my lord, what the state is trying to impress upon the court is that here we have a case which is the origin of much of the authority, which tells courts, with very good reason, not to entertain delaying tactics. This is the very case. And yet, we get to another delaying tactic, and because of the application for postponement, in this very case, where we are told by the courts, all courts, particularly courts in this case, we are told, don't do it. Do not entertain delaying tactics and further postponements, which have the effect of delaying justice and which erode the public's confidence in the system of justice, because it's yet another postponement in a long-running series of postponements, and is yet another unending end of the end.
As regards the eroding of confidence, the solution might lie in rather statutory amendments.
Indeed, my lord. Yeah, absolutely.
Yeah.
Absolutely. And I think, you know,
I think we're all aware,
Yes.
divorce it from the facts of the present case for the moment. There are instances where, certainly as a judge, I can sit and write what I think is hopefully a very persuasive judgment with extensive reference to authorities, particularly in a civil context, and written as persuasively as I can. And then I get a 2-page notice of application for leave to appeal that says the judge failed to attach sufficient weight to the authorities referred to. And that suspends my entire judgment, my considered judgment, for weeks and weeks and weeks. And one can understand the frustration of the public, but maybe the solution there lies, as I say, in statutory amendment. Maybe it's something for the Law Reform Commission to consider.
My lord, yes, I would agree fully with your lordship, but fortunately, I would say, and this is our submission, the legislature has stepped in criminal cases. It has. So we say that in that respect, the amendment of the Superior Courts Act, 10 of 13, which removed Chapter 5 criminal proceedings from the ambit of the Superior Court Act appeal provisions, that, as your lordship has already found, and it's obviously correct, that was designed in reaction to the Tint judgment in this very case. So your lordship has found in the main judgment. And the reason for that is because of the policy that the legislature said, we are sick and tired of criminal cases being postponed for reasons of appeal, which ultimately turn out to be unsuccessful and not groundless, and yet delay proceedings. So our very strong submission to your lordship is this is precisely the case where this court, my lord, with great respect, is entitled to exercise discretion in terms of 168, as it did in the main and leave to appeal judgments, to say, unfortunate as the accused might find it, his right to appeal during this case before his conviction unfair as he might find it, or as inconvenient as he might find it, because it means that his trial has to start, that there is a solution which has been offered, which this court has found and given effect to, and which is frustrated should this court grant a further postponement in terms of 168. So in very short, in the bottom line, my Lord, is that we're saying that the solution is there, even though it's imperfect and is bedeviled by the reintroduction of the Superior Courts Act at the appeal court level to criminal cases. And that might be a problem, but fortunately, our submission is that this court does not have to be caught up in that problem. And the solution is indeed to take account of our submissions relating to the context of this matter. And that brings us also on to the merits of the application, my Lord.
Yeah.
And I'm entirely sympathetic, my Lord, to my learned friend's problem and this court's problem, that this court obviously is not the appeal court. It's not the two judges, and it's not the president of the Supreme Court of Appeal. But nevertheless, this court, having made the having delivered its judgment in the section 106.1.1h application and the leave to appeal judgment, has formed views as to the merits of the 106.1h application, and those views remain. And this court can gain comfort from the fact without going into the legal suspension of it. But the SCA and the two judges of the SCA have indeed agreed with it. So all of that is this court's discretion, and this court is not bound not to exercise a judgment on the papers which are before your lordship. They're put before your lordship by my learned friends. So your lordship has has the application, and we submit in paragraphs 6 to 12, in our heads at pages 6 to 12, in paragraphs 18 to 30, we submit that this court is quite properly, may quite properly have regard to those, to the merits of the application, and we develop our argument, we submit strongly, that the submissions have problems. And just to be short, my Lord, the gross error, we say, if in my learned friend's papers, they say that the SCA committed a gross error by by saying that the application had been dismissed as having no reasonable prospects of success and there being no other circumstances, and that they don't know, does this mean, which application is it? Is it the 106.1h application? Is it the other applications for reservations of questions of law, etc.? Is it a petition? Or is it? And we just say in our heads at those pages that if you analyze it properly, it really is just a made-up application. There is no confusion, and it just appears to be an attempt to put the application in the realm of exceptional circumstances, when really there are no such exceptional circumstances, and the so-called error is not an exceptional circumstance. So it is not a proper application, falling within those grounds.
But whether there are exceptional circumstances ultimately will be decided by the president of the SCA.
Absolutely.
It's that decision.
Of course, my Lord, but this is put before your lordship, and we submit that the lack of merit in the application is obvious. But it's this court's view of that, and this court is not supplanting its judgment or trying to impose its judgment on the other courts, obviously. And then we deal in our heads well, my learned friend doesn't develop the utterances of the NPA. I'm not going to refer to that at pages 15 to 16 and 35 to 36 of our heads.
Do you want to say anything about section 18.2 that you relied upon?
My Lord, yes. We say that section 18.2 is the spirit of section 18.2.
But the reference to not having the effect of a final judgment?
Well, in the Supreme Court of Appeal, yes, but not in this court.
No. But what we're talking about being suspended there is the order of the two judges in the Supreme Court of Appeal.
Yeah, no, we've
that
made
was final in effect.
Yeah, well, we've made the concession that it's really immaterial whether it's in terms of one or two.
Oh, I see. Okay.
Yeah. And then, my Lord, we also deal in our heads at pages 17 to 18 at paragraphs 41 to 43, the fourth new ground of the charges against me, but my learned friend hasn't developed them, and Your Lordship, I think, has quite correctly, with great respect, confined the issues to this court in terms of the application to the Supreme Court of Appeal. Yeah, so, and then we also deal with the accused replying affidavit filed on the 10th of April, which were after our heads. There's no need for me to do so because my learned friend hasn't relied on them, and the issues are confined.
To me, and that's why I dealt with it at the outset, the factual matrix within the confines of which this application is to be considered are those that I referred to earlier on.
Indeed.
It's a Section 17(2)(f application.
Yeah.
It's the petition, the refusal of it, and the application for reconsideration.
So just to sum up then, my Lord, we seriously make the submissions that this is a very special case, and it simply makes no sense where this case is the one that has bothered courts, has bothered the legislature. The legislature has changed the law to accommodate the types of irregularities and unfortunate situations that happen in this case, and is the very case which allows this court to exercise its discretion in terms of Section 168 and to allow the state to get on with the trial and all the parties in the interests of everyone, this court and the public, as it pleases the court. My Lord.
If I am disposed to granting the adjournment, I take it, should it be sine die or to a specific date, I take it you would support the latter, is it?
Absolutely. And that Kotenberg judgment which we put up and which my learned friend refers to from the Western Cape, it's not exactly in point because it refers to an appeal, not a criminal case which is pending. And they're very different considerations which apply to the finalization of appeals. And we would say that in criminal cases in general, and particularly in this very case where we were beset with problems in finalization, that I heard Your Lordship's comments that naturally this court should retain judicial control, and we don't. Our submission is that sine die actually is not an option open to a court in a criminal case such as the present, which is part heard and has already commenced. And if you look at Section 168, it says there in terms that the court may postpone the matter to a date.
Yes.
Now, a sine die no date is not a date.
Mm-hmm.
So we say that apart from criminal appeals, a criminal trial must be postponed to a particular date.
The notion of a holding date with the matter proceeding thereafter, is any comments on that?
My Lord, we're in Your Lordship's hands. We are in the dark as the court and my learned friend are about how long it takes the SCA. We were surprised, not surprised, we were happy to see that the SCA gave judgment, with the two judges gave judgment soon and delivered it on the 28th.
I think the affidavits from Mr. Zuma's side have referred to it as uncharacteristic. But
Yes.
I don't, from personal experience, don't find it uncharacteristic because petitions get distributed and they normally dealt with within a couple of days,
Indeed.
even less than this.
Yeah.
So I don't know that it's uncharacteristic, but that's by the by, it's not important.
Absolutely. So, but apparently the papers go to the judges every Tuesday, and the judges deal with them as soon as they get them, and it depends on the nature of the papers and the quality and the length. I would submit, my Lord, that given Your Lordship's judgments, that it is possible that it could be sooner rather than later. One would hope.
Any suggestion on a holding date?
Yeah.
It's been suggested maybe the end of May.
Yes, the end of May.
The end of May?
Yeah, I've got my diary with me. Perhaps we could take the adjournment and just work out the...
Sorry, I didn't watch the time. Has that concluded your submissions?
Yes, my Lord, yes. Yeah.
Mr. Mpofu, shall we take the short adjournment now?
After my reply.
Before your reply?
We can, yes, my Lord, we can.
I'm happy to continue and hear your reply. I don't know how long it's going to be. I presume not too long.
Well,
but it's subject to whether council require a comfort break at this point.
no, they don't.
Yes.
Yes, no.
All right. Well, then deal with your reply, and we can deal with the matter thereafter.
Yes, my Lord.
Mr. Mpofu, it was explained to me this morning that the machine needs to be stopped every now and again so that if there's a problem with recording, then it's a shorter interval that might have to be reconstructed or whatever. So we're just going to do that, just stop it, and then it'll resume. But we can all just remain in situ as we are.
Okay. We don't have to go.
Just don't talk, and it'll be indicated when we can start again. Okay. You may continue, Mr. Mpofu.
Thank you, my lord. My lord, yes. Unfortunately, your lordship stopped me from dealing with some of the points, but seeing that my learned friend has covered those points, then I have no choice but to deal with them. My lord, but
Mr.
before...
Mpofu, I didn't think I stopped you, but I actually invited you to raise other points as well.
Yeah, well,
Be that as it may.
I'm taking
let's
the
deal with it.
invitation now.
Yeah.
Okay, that's fine, my lord. Yeah, no, what I understood from that, my lord, the reason I didn't develop the other points is because I thought your lordship was confining it to that point. But now we've gone to Stalingrad and all sorts of things, yeah. So we're going to have to deal with that.
Well, I think it's more appropriately perhaps dealt with in reply.
Yes.
You accepted that the protection of Section 18, if one should refer to it as protection, the effect of Section 18 might be lost in instances of mala fides.
No,
And I think,
I didn't say that, my lord.
well, not mala fides, but if it's abused.
Yes, if it's abuse of I said, my lord, let me maybe say it myself. Yeah. I said that if you look at it from the point of view of Section 17 and 18, then your lordship will have no discretion.
Mm-hmm.
But I considered that if your lordship can't, neither can I, rewrite Section 168, which uses the word may.
Mm-hmm.
So clearly there is some kind of discretion. It might be illusory, it might be limited, but the word may can only mean that. Yeah. And then in light of that, in light of that concession, I then said, my lord, even in those cases, it would be in the cases of clear-cut mala fides.
Yeah.
And I think my learned friend has summarized it correctly.
And that's what he picked up on.
Yes. All right.
And that you want to reply to now.
Yes. Let me start with that then, my lord. The issue of mala fides, and your lordship is quite correct that it's better dealt with in reply because of where the onus lies, as I will show your lordship now. And as we said in our heads, really that's the only defense that has been raised, and let's just make short thrift of it. Fortunately, my lord, this what they've called the Stalingrad defense has been defined, and the lordship hit the nail on the head just now. There's a case that was discussed, decided last week or so in the High Court of South Africa Division in Johannesburg. It's case number 13276-2014, my lord. I'm sorry, I only got this this morning, so I'll give my learned friends a copy. But the point I make is not a big academic HE point. This was Judge Makume. It's Mutumwa Mawere versus IDC and others. Your brother Makume J in Johannesburg said the following at paragraph 15. The history of this matter clearly indicates the deliberate abuse of court process by the applicant. He not only ignored the court orders and directives that I issued and has instead mounted a protracted Stalingrad type of process aimed at preventing the IDC from executing a judgment in its favor. The only thing I want to pick out, my lord, is what your lordship said correctly, that that type of defense in normal language, in Stalingrad is like a term of fashion, is really abuse of court process. for an ulterior motive. Now, I don't want to go through the 7 reasons we have put in our heads why that defense cannot be sustained. All I want to say is this, my lord, that the abuse of process, as we all know it, is defined as follows. It's defined in the case of Baynash versus Weeksley, that your lordship knows about, 1997, bracket 3 SA, 721 SCA, especially at 734H. It was also referred to in another case, my lord, called SA Coaters, Coaters, Pty Ltd versus St. Paul Insurance Company Limited, 2006, 2007, 6, SA 628. Sorry, I just, for some reason, I don't have the division here, but if I stand corrected, I think it's the SCA. The bottom line was that a party that is suggesting abuse of court bears the onus to establish that completely and establish it, particularly in a case like this where it is being flagged as the sole motive, the ulterior motive. So it's not something that is lightly made by the courts from newspaper articles and corridor gossip. There must be a discharge of an onus, and nothing in this particular case has been put. So even if there was such a discretion, the court would easily be able to determine that the onus has not been discharged. More so, if, as we all now agree, it's common cause that the first accused is exercising his appeal rights as provided for in the Superior Courts Act, as provided for in the Constitution, and as provided for even in Section 34 of the Constitution. So it is not clear, unless if he is a special type of person who's not allowed to appeal, unlike other human beings. And there's no case that has been made for that. Then, my lord, your lordship is quite correct. My learned friend is making a mistake. You cannot even deal with the issue of prospects of success or the merit or meritlessness or whatever of the reconsideration application. The law is very simple, my lord, and the lordship is quite correct. Maybe there should be a statutory amendment. And in fact, to be fair, our courts have effected that amendment in the context of Section 18.1. The lordship will know that the statute itself only puts 3 standards: exceptional circumstances, no harm to the one and no harm to the other. But the courts have developed a 4th standard, which is not in the statute, which is prospects of success. Correctly so, because it's a gap, as the lordship says. Because the statute doesn't say if you bring a merited appeal. It says if you bring an application for leave to appeal, full stop. Then it's suspended. But what my learned friends are busy doing, my lord, is to try and bring to this court a Section 18.1 application through the back door. You cannot do that. There's no Section 18.1 application before you, and therefore, by operation of law, the judgment is suspended. If they wanted to bring an 18.1 and talk about prospects of success and exceptional circumstances and what have you, they are free to do so. They can do it tomorrow if they want, but they can't sneak it through the back door. So that's the first point. Secondly, this notion of trying to unscramble the egg cannot work, my lord. You cannot say that the judgment of the 2 judges is suspended, but the underlying judgment, which is the real one being appealed against, is not suspended. What is that? It is true that primarily Section 18.1 would operate, as I said earlier, against the Section 17 counterpart, so to speak. But the reality is that which is being appealed against is your Lordship's judgment. And that is effectively what is. So if your Lordship said return the car, and then we go and petition, and then it's suspended, then I don't return the car, unless if there's a Section 18.1 application. So that's an artificial distinction with no meaning whatsoever. Moreover, my Lord, your Lordship's judgment, I'm sorry, just... I forgot the Koen's judgment.
What, on the leave to appeal one, or
Yes, the second one, my Lord.
yeah?
And I'm looking specifically at the order. I actually took it out and put it, if your Lordship just bears with me. Okay. Thank you, my Lord. It's part of the...
Part of the reconsideration application.
Yes, and the petition. Your Lordship goes to paragraph 139 of the judgment, the February judgment. Then you'll see that the state's
139, yes?
139.
Mm-hmm.
That's the order.
Yes.
The state's argument here is not only disingenuous, my Lord, it actually flies in the face of the logic of what was decided by your Lordship. Now they're saying, no, there was one application, or here it's used in the singular and what have you. Your Lordship was very clear. It says, I issue the following orders. 1, the application for leave to appeal and all related applications in a plural, which include the application to adduce further evidence on appeal, the application for leave to appeal to the SCA on the grounds of Section 317, special entry, and so on and so on. So the Lordship was very clear that he was not granting an application in respect of one matter, but of 4 different matters. The SCA has unfortunately created an ambiguity which was unnecessary, because all they really could have done is to look at your Lordship's order and use the same grammar of the applications. But what they say is that the application is dismissed, and the words they used are the giveaway, my Lord. They say because there are no reasonable prospects and no other compelling reasons. Where do those words come from? Section 17.1 of the Superior Courts Act. So it's very clear that they did not consider anything else except the application for leave to appeal. They did not consider the application to adduce further evidence, the special entry, and the 319. We may be wrong, of course, my Lord.
Yeah, I'm not sure whether you're right on that, because
well, I'm not sure either, but that's not the point.
The petition was one application. Sorry, I still use the old words.
Yes.
Petition. There was an application for leave to appeal to the SCA, and then it referred to the petitions. And the petitions included then, amongst others, the ones on 317, 319, as provided for in terms of 3175 of the Criminal Procedure Act. But the long and the short of this, Mr. Mpofu, I don't think we need to debate it.
No, we don't.
Because I can't express a view on that.
Yeah.
That's the president of the SCA will say, your submission about it, that they only dealt with one, is fallacious, or she might say, no, it's good.
Yeah.
But I can't answer that.
Yes.
What your point is, we must await the outcome of her decision.
That's my point, my Lord. But because
So
Mr.
what
Downer,
it means,
because Mr. Downer addressed it and called it, what did he call it? Meritless, made-up application. I have to, your Lordship has to allow me to deal with that, because that's an insult apart from anything else. So I'm saying that, my Lord, you're quite right.
Yeah, I'm not precluding you from dealing with it. I'm just saying that it's not within my domain.
Yes. And my Lord, you know that is what we said in our heads, we've said two things, which are points of law. One, your lordship does not have the jurisdiction to consider the prospects of success in a higher court. That would be disrespectful apart from anything else, or lack of deference. So I agree with your lordship. The second one, we've said, on the issues themselves, your lordship is functus officio. You can't revisit your judgment because you've already given it. That's not what we're here about. So on both the jurisdiction ground and functus officio rule, your lordship is quite correct. You are precluded from revisiting those. But I'm just saying that in this court, it was said that this is a so-called made-up application. And I have to respond to that by explaining that your lordship himself used the plural applications. They themselves, the state, used that before they became clever after the fact. In their answering affidavit, you will find about 6 references where they talk about the petitions and the applications. And of course now, after last week, they've now changed. That's disingenuous. That's just clear disingenuity. So the application, whether it will succeed or not, your lordship is quite correct, but nobody standing here can say that the SCA has dismissed the 1 or 2 or 3 or 4 applications. And it might be a question of clarification even at that level, my lord. Right. So that just shows that even if your lordship was entitled to look at prospects of success, then it would be, at least the case would be arguable. The next thing, my lord, is that it is said that your lordship, the second order that your lordship gave that day was that the trial would start today. That order is also susceptible to what I've just said, because that order is also part of the symbiotic relationship between the appeal itself and the decision of the
It's obviously an order that I made on that day.
Correct.
The facts as they existed.
Yes.
And the stage of the proceedings that had been reached.
All things being equal. Correct. So, but the point, I'm making a bigger point, my lord, which is that that order itself is suspended ipso facto because of the effect of Section 18. And if we accept that there's one transaction here, it's your lordship's judgment, and then it's the SCA decision, and then it's the impact of Section 18. But I don't want to dwell on that much.
Yeah, I'm not too sure about that, but anyhow, I take it on. The decision that's suspended is clearly the one by the 2 judges.
Yeah, but
Yeah.
my lord,
No.
yes, I don't want to debate this, but I mean that would be so artificial. As is the example that I'm saying. If you can say the decision of the SCA is suspended, but the underlying decision, which is the one about
Therefore
whether
revives.
is not suspended, what is that? How can that be, my lord?
No, I hear
That's illogical.
I understand that submission.
As the court pleases, my lord. Yes. So then my learned friend went on about 2 decades. I'm not going to entertain that. We were not here 2 decades ago. The issue now is that the trial has started, and we know that, as he has done today, and this I have to say, my lord, this gratuitous insult of ulterior motive and Stalingrad and delays and so on is not borne out by the evidence before your lordship. I don't know what happened in other courts. But before this court, my lord, Mr. Zuma has consistently done everything in his power for this matter to proceed. On the 21st and 22nd of September, while he is entitled to be sitting here when we were doing the Section 106, he gave your lordship permission. He waived his rights. Those were the words that were used. He waived his rights to be in court so that the matter may proceed. Today, he has done the same thing. Anyway, so, my lord, far from any suggestion of Mr. Zuma trying to do all the things that he's being accused of, the evidence before your lordship is the exact opposite. of a person who is prepared to even waive his own constitutional rights so that the matter may proceed. Prospects we've dealt with. Yes, really, my lord, all I can say is that the answer might well lay in a statutory amendment. I just want to, before I sit down, if your lordship allows me, just to refer your lordship to some of the references in the answering affidavit. Sorry, my lord. Okay. I'm sorry, my lord. This it's something I have to do. Otherwise, I won't be able to sleep at night. Sorry, my lord. If your lordship goes to the records of these proceedings, you will find the answering affidavit at page 21.
The answering affidavit.
Yes, the state's answering affidavit.
Yeah. Page 21.
It starts at page 21, my lord. Yes, thank you. Yes, I found the one that's... If your lordship goes to page 2, typed page 2, which is page 22. This is the state themselves. They say, in summary, the grounds of opposition, this is before this newfound grammatical Damascus moment. They say, in summary, its ground of opposition, that is our grounds, are the following. 6.1, the petitions to the SCA do not suspend all the proceedings in the criminal trial. So they themselves used it in the plural. The following page, 6.5, my lord. They say, this is Mr. Duploy's affidavit. The state respectfully considers that the grounds raised in the petitions do not provide the court with any reason to alter such a finding. It is not in the interest of justice to postpone the current trial to allow the petitions to the SCA to run their extended courses. 6.6, the same thing. The state contends that the current application for an adjournment pending the outcome of the petitions to the SCA, the heading below that, whether the petitions to the SCA suspend the continuation of the trial. 7, Mr. Zuma's 4 petitions to the SCA are framed as follows, and so on, and so it goes. So it's just pure disingenuity to now tell us that it has been referred to in the singular, when they themselves knew that there were 4 separate petitions. And I've already shown that even your lordship in the judgments also used the plural, which everyone should have. And maybe the SCA, all they could have done is simply that if they had said the applications or the petitions, there wouldn't be this ambiguity. But as we sit here, there is now. My understanding, my lord, was that the Mr. Downer is not opposed to the regime that we discussed, but obviously he needed to look at his diary. So what I would then propose, subject to what Mr. Downer has to say, is that we take the adjournment so that we can compare diaries and then
That's now in the event of the postponement being granted.
in the event of it being granted.
Yes. Well, can you do that? Sorry, Mr. Dana.
I'm sorry.
So just to be of assistance, we've looked at our diaries, and 4 weeks would bring us to either the 17th of May, which is a Tuesday, as a provisional day, or the 24th a week later, which is
All
a
right.
Tuesday.
Have you got information on that, Mr. Mpofu? Somebody's trying to give you a note there from.
Yes, my lord.
So that'll be a holding date.
My lord, yes. Can we do the earlier date? I know that I've got something on the 23rd or 24th. Can we do the 17th? Yes.
Okay. Yes. Does that conclude all the submissions to be made?
On our side, my lord, does the court please?
I'll take the adjournment. I just want to reflect on the arguments, and I'll give my order, possibly with brief reasons, but otherwise detailed reasons to follow later, although it's an interlocutory, either later or then in the final judgment, if there is one. I'll do that at 2 o'clock.
As court pleases, my lord.
Court will rise. Having heard the argument of counsel, and in the light of the public interest this trial has enjoyed, I provide the following brief reasons for the order that I have concluded should be granted in regard to Mr. Zuma's application for an adjournment. These brief reasons are not exhaustive of all the arguments that were considered, and I reserve the right to amplify these reasons in the fullness of time, should the need arise, although the order granted is interlocutory in nature. Following my judgment of 26 October 2021, dismissing the plea in terms of section 106(1)(h), that is the special plea, read with section 106(4) of the Criminal Procedure Act 51 of 1977, Mr. Zuma filed an application for leave to appeal against the dismissal of the special plea, applying also for further evidence to be adduced on the appeal, applying for leave to appeal to the Supreme Court of Appeal on the grounds of section 317 of the Criminal Procedure Act, and stroke all for a special entry of an irregularity or illegality to be made on the record, and then finally applying for leave to appeal to the Supreme Court of Appeal on the grounds of section 319 of the Criminal Procedure Act 1977, and stroke all for the reservation of questions of law for consideration by the SCA. On 16 February 2022, I dismissed the application for leave to appeal and all the related applications, and directed that the criminal trial should proceed during the second and third terms of the 2022 calendar of this court, commencing at 10 o'clock on the 11th of April 2022, being the date also to which the trial was previously adjourned on the 26th of October 2021. On the 4th of March 2022, Mr. Zuma filed a petition against my aforesaid judgment with the Supreme Court of Appeal, seeking leave to appeal to that court. On the 18th of March 2022, Mr. Zuma filed an application in terms of Section 168 of the Criminal Procedure Act for the postponement of the trial due to commence today, that is the 11th of April 2022. His application was based on the petition pending before the Supreme Court of Appeal that he wished to exhaust all rights available to him and that this court should exercise its discretion to adjourn the matter either sine die or to a date to be fixed. On the 31st of March 2022, the two judges of the Supreme Court of Appeal dismissed the application for leave to appeal. On 7 April 2022, Mr. Zuma filed a notice of application in terms of Section 17(2)(f) of the Superior Courts Act 10 of 2013, which I shall hereinafter refer to as the reconsideration application, with the registrar of this court. This reconsideration application was filed with the registrar of the Supreme Court of Appeal on the 8th of April 2022. Section 17(2)(f) of the Superior Courts Act provides, and I quote, "The decision of the majority of the judges considering an application referred to in paragraph B, or the decision of the court, as the case may be, to grant or refuse the application shall be final, provided that the President of the Supreme Court of Appeal may, in exceptional circumstances, whether of his or her own accord or an application filed within 1 month of the decision, refer the decision to the court for reconsideration and, if necessary, variation." Section 17(2)(f) of the Superior Courts Act applies to both criminal and civil matters. It is common cause that the application for the adjournment before me today is now in the main based on this reconsideration application in terms of Section 17(2)(f) of the Superior Courts Act. Whether the special plea is appealable, or more correctly, whether the dismissal of the special plea is appealable prior to conviction, which I had found that it was not, and whether, if it is appealable prior to conviction, such appeal will be governed by the provisions of the Criminal Procedure Act or the provisions of the Superior Courts Act, which, regardless of the basis thereof, I had refused, are not the issues which now arise for consideration. I had previously decided those and am, in regard thereto, functus officio. The issue for consideration is the reconsideration application that has been filed with the President of the Supreme Court of Appeal and which awaits her decision as part of the further appeal process. Whatever the legal position might be as regards the appealability of the dismissal of the special plea prior to conviction, and if competent, specifically whether it is an appeal in respect of a matter regulated in terms of the Criminal Procedure Act or in terms of any other criminal procedural law as contemplated in the definition of appeal, or whether it is an appeal in terms of Chapter 5 of the Superior Courts Act, or whether there is some other statutory basis for entertaining such an appeal, a reconsideration application is patently an application in the appeal process expressly recognized in Section 17 of the Superior Courts Act dealing with leave to appeal generally. It is therefore an application governed by the provisions of Chapter 5 of that Act. Accordingly, since the filing of the reconsideration application, the decision of the SCA dismissing the application for the various petitions made to it is, quote, "a decision which is the subject of an application for leave to appeal or of an appeal," unquote. That is, to obtain leave to appeal in respect of the dismissal of the special plea on reconsideration as contemplated in Section 18(1) of the Superior Courts Act. The reconsideration application is part of an application for leave to appeal. Sections 18(1) and 2 of the Superior Courts Act provide, and I quote, 1, subject to subsections 2 and 3, and unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision which is the subject of an application for leave to appeal or of an appeal is suspended pending the decision of the application or appeal. Subsection 2 provides, and I quote, subject to section 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is an interlocutory order, not having the effect of a final judgment, which is the subject of an application for leave to appeal or of an appeal, is not suspended pending the decision of the application or appeal. The Supreme Court of Appeal's dismissal of the application for the petitions is not an interlocutory order, nor does it not have the effect of a final judgment, as contemplated in Section 18(2) of the Superior Courts Act. An application to reconsider an order of the Supreme Court of Appeal refusing a petition is an application for leave to appeal or of an appeal as contemplated in Section 18(1) of the Superior Courts Act. The operation and execution of the decision of the SCA dismissing the application containing the various petitions is accordingly suspended by operation of law. With due deference to the procedures and jurisdiction of the Supreme Court of Appeal, it means that the procedure is suspended and that the trial cannot proceed and should today be adjourned. That follows as a matter of law. It does not seem to me that this court has much of a discretion, if it has one at all, to deny those appeal rights statutorily ordained, unless perhaps in the clearest of cases where there is an abuse of rights. The appeal process should be allowed to run its course. Mr. Zuma has challenged many decisions adverse to him in the past, usually invoking the entire appeal process to the highest courts in this land, and in many instances has been unsuccessful, which resulted in inevitable and unfortunate delays. He is also on record through previous counsel representing him that he will continue to exercise all rights available to him. But the exercise of those rights, as much as they may be viewed with suspicion and distrust from certain quarters as resulting only in delays, which only favor him, do not per se amount to an abuse of those rights. A finding of mala fides would require more and clear proof by the state, which I cannot make on the allegations in the present papers alone. On the peculiar facts relating to this matter, a final decision from the Supreme Court of Appeal as to whether it might revisit its decisions inter alia in Ndluli and Porrit as clearly wrong, remains outstanding until a decision is taken whether to reconsider the decision on petition or not. The opportunity for reconsidering that outcome and other possible relevant considerations in the application for the various petitions by the SCA, although it will regrettably result in further delay, is statutorily ordained. To the extent that it will result in delay, it would be a delay which would not be unreasonable, but in our constitutional democracy, on the law as it presently stands, unfortunately unavoidable. When weighing all the relevant facts and circumstances alluded to by the parties, the conclusion I have reached is that the trial must be adjourned to allow the reconsideration application submitted to the President of the SCA pursuant to the proviso to Section 17(2)(f) of the Superior Courts Act to be disposed of. Criminal trials are not generally adjourned sine die. There is no compelling reason why the present trial should be adjourned sine die. It is well overdue. As much as the interests of justice demand that Mr. Zuma's reconsideration application should be allowed to be disposed of, there is also the interest of justice that demand that litigation must reach finality. The future progress of the trial must be closely managed by appropriate judicial oversight. As soon as the decision of the President of the Supreme Court of Appeal is made and those proceedings are disposed of, the trial should proceed, absent any other compelling reason. The trial was adjourned on the 26th of October 2021 to the second and third terms of the 2022 court calendar of this court, commencing on 11 April 2022. In view of the delay which will result from the adjournment, provision must be made for the continuation of the trial also into the fourth term of this court's calendar. The following order is therefore granted. A, the trial is adjourned to 17 May 2022 as a holding date, pending the decision of the President of the Supreme Court of Appeal in respect of Mr. Zuma's application in terms of Section 17(2)(f) of the Superior Courts Act 10 of 2023. That more correctly should read in terms of the proviso to the section. B, the adjournment is granted on the basis that if the application in terms of Section 17(2)(f) of the Superior Courts Act has been disposed of by 17 May 2022, the trial shall resume at 10 o'clock on the 31st of May 2022 and shall continue thereafter for the remainder of the second, third and fourth terms of the 2022 court calendar of this court. C, if the reconsideration application has not been disposed of by the holding date, then a further holding date and date for the continuation of the trial shall be determined on the holding date. And then I've added, more particularly for your client, Mr. Roo, D, on the basis that the accused undertake to appear on 31 May 2022 or any subsequent date fixed for the resumption of the trial, Mr. Zuma and the representative of Thales are excused from attendance on the holding date and any subsequent holding date that may be fixed by the court. And that is the order.
And please the court, no?
As the court pleases, my lord.
Court will rise.
Okay, guys.
Okay, see the holding date. Maybe not even there.